The Supreme Court could dismantle a pillar of voting rights, and it might change elections forever. Imagine a law designed to right the wrongs of centuries of racial discrimination, ensuring that millions of voters from underrepresented communities have a real shot at electing leaders who look like them and fight for their issues. That's the Voting Rights Act of 1965, a landmark piece of legislation born from the brutal battles of the civil rights movement. What now? The conservative-leaning Supreme Court is poised to potentially tear apart one of its most crucial sections, and the implications could ripple through American democracy. Stick around. This isn't just legal jargon. It's a fight that could reshape who holds power in our country. In a dramatic turn, the justices are set to hear oral arguments this Wednesday in a high-stakes case from Louisiana. At its core, the debate centers on whether states can take race into account when redrawing congressional districts to adhere to Section 2 of the Voting Rights Act. This provision was crafted to shield minority voters from discriminatory practices that had historically barred them from the ballot box. Think about it. Without protections like this, entire groups could be effectively silenced in elections, a nightmare scenario that echoes the dark days of Jim Crow. The backstory here is a long-simmering conflict over Louisiana's congressional map. Last year, after facing a lawsuit under the voting rights, the state was compelled to redraw its districts to guarantee 2 majority black areas. The previous version only included one such district, despite black residents making up roughly 1/3 of the state's population, a clear mismatch that highlighted potential disenfranchisement. It's like trying to fit a puzzle piece in the wrong spot. The law demanded a fix to ensure fair representation. But here's where it gets controversial. The Supreme Court, in an unusual move, expanded the case's scope over the summer. Originally focused on narrower legal questions, they asked the parties to re-argue it, zooming out to a bigger constitutional clash. Now, the justices must decide if creating districts with majority black populations crosses the line, violating the 14th and 15th Amendments. These amendments, passed in the wake of the Civil War, aimed to secure equal rights for formerly enslaved people, including the fundamental right to vote. Yet, some argue that considering race in any form undermines the very fabric of equality. But is that truly fair, or does it ignore the lingering effects of past injustices? Conservative voices on the court and beyond push for a colorblind reading of the Constitution, where race plays no role in government decisions. This echoes their recent 2023 decision that banned race-based considerations in college admissions, emphasizing merit over identity. In this case, Louisiana, which initially backed its revised map, has flipped sides, teaming up with a coalition of self-described non-African American voters suing to halt it. Even the Trump administration has thrown its support behind this shift, signaling the political weight behind this challenge. On the opposing side, civil rights organizations that originally sued to force the map changes are defending it tooth and nail. They're arguing that race must sometimes be factored in to counteract historical barriers, like gerrymandering that dilutes minority voices. And this isn't the first time the Voting Rights Act has faced scrutiny. The Supreme Court has chipped away at it before, with major blows in 2013 and 2021 that limited its reach. But just 2 years ago, in a surprising twist, the court upheld the need to use race in redistricting when required by the law in an Alabama case. That 5-4 ruling saw even some conservatives, like Chief Justice John Roberts and Justice Brett Kavanaugh, join the liberals, though Kavanaugh hinted at doubts about Section 2's long-term viability. And this is the part most people miss. These shifts show how fragile the law's protections are, teetering on the knife's edge of judicial philosophy. If the court rules broadly in Louisiana's favor, it could make it far less necessary for states to create districts dominated by minority groups, potentially slashing the number of Black, Latino, and other underrepresented lawmakers in Congress and state houses. With Black voters leaning Democratic in many elections, this shift might hand Republicans an edge, altering the political landscape. Plus, A swift decision could give states like Louisiana time to redraw maps before the 2026 midterm elections, turning legal deadlines into strategic opportunities. The Voting Rights Act has been a beacon for equality, but attacks on it reveal deep divides in how we interpret justice. Is a colorblind approach the ultimate fairness, or does it blind us to ongoing inequalities? What do you think? Should race ever factor into redistricting to ensure true representation? Or is it time to move beyond such considerations? Share your thoughts in the comments. I'd love to hear why you agree or disagree, and if there's a counterpoint I've overlooked. Let's keep the conversation going. Democracy depends on it. Lawrence Hurley is a senior Supreme Court reporter for NBC News.